Stipulations. Seller usually makes certain statements or representations about quality, nature, price with a view to induce the intending buyer to purchase the goods. Representation, which forms a part of contract of sale and affects contract, is called a stipulation. Conditions and warranties. Condition. A condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. Warranty. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages but not to a right to reject the goods and treat the contract as repudiated, where breach of condition be treated as breach of warranty. As a result, buyer loses right to rescind the contract and can claim damages only. In the following cases, contract is not avoided even on account of a breach of a condition. 1. Where buyer altogether waives the performance of the condition. A party may for his own benefit waive a stipulation. It should be a voluntary waiver by buyer. 2. Where buyer elects to treat the breach of the conditions as one of a warranty. He may claim only damages instead of repudiation. Here, buyer has decided to treat it as a warranty. 3. Where contract is non-severable and buyer has accepted either whole goods or part thereof. 4. Where the fulfillment of any condition or warranty is excused by law by reason of impossibility or otherwise. Express and implied condition and warranties. Conditions and warranties may be either express or implied. Express conditions are those which are agreed upon between the parties at the time of contract. Implied conditions are those which are presumed by law to be present in the contract. Following conditions are implied conditions unless contract shows a different intention. 1. Condition as to title. In case of a sale, he has a right to sell, and in case of agreement to sell, he will have right to sell unless agreement to contrary. If seller's title/ownership is defective, buyer must return the goods to the true owner and recover the price from the seller. 2. Sale by description. Where there is a contract of sale of goods by description, there is an implied condition that the goods shall correspond with the description. This rule is based on the principle that if you contract to sell peas, you cannot compel the buyer to take beans. The buyer is not bound to accept and pay for the goods which are not in accordance with the description of goods. If goods tendered do not correspond with the description, it would be breach of condition entitling the buyer to reject the goods whether the buyer is able to inspect them or not. 3. Sale by sample. In contract of sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality. The buyer shall have a reasonable opportunity of comparing the bulk with the sample. The goods shall be free from any latent defect rendering them unmerchantable, which would not be apparent on reasonable examination of the sample. If the defects are latent, then the buyer can avoid the contract. Means goods shall be free from any hidden defect. 4. Sale by sample as well as by description. Where the goods are sold by sample as well as by description, there is an implied condition that the bulk shall correspond both with the sample and the description. In case the goods correspond with sample but do not tally with description or vice versa or both, the buyer can repudiate the contract. 5. Condition as to quality or fitness. Ordinarily, there is no implied condition as to quality or fitness of goods sold for any particular purpose. However, reasonable fitness may be implied provided following conditions are fulfilled. 1. Buyer made known to the seller the particular purpose for which goods are required. 2. The buyer should rely on the skill and judgment of the seller. 3. The goods must be of a description dealt by the seller, whether he be a manufacturer or not. This implied condition will not apply if goods sold under trademark or patent name. Where the goods can be used for only one purpose, the buyer need not to tell the seller the purpose for which he requires the goods. General rule: it is the duty of buyer to examine the goods thoroughly before he buys, to satisfy that goods will be suitable for his purpose. This is known as rule of caveat emptor, which means, let the buyer beware. 6. Condition as to merchantability. Where goods are bought by description, there is an implied condition that the goods shall be of merchantable quality. There are 2 requirements for this condition to apply. 1. Goods should be bought by description. 2. The seller should be a dealer in goods of that description. Provided, if buyer has examined goods, there shall be no implied condition as regards defects which such examination ought to have revealed. Merchantable quality means goods of such a quality, and condition as a man of ordinary prudence would accept them as goods of that description. 7. Condition as to wholesomeness. In the case of eatables and provisions, in addition to the implied condition as to merchantability, there is another implied condition that the goods shall be wholesome. Following are implied warranties. Implied warranties. It is a warranty which the law implies into the contract of sale. It is presumed that the parties have incorporated it into their contract unless expressly excluded. 1. Warranty as to undisturbed possession. buyer shall have enjoy quiet possession of goods. If the possession of the goods is later on disturbed in buyer's possession, he is entitled to sue the seller for breach of warranty. 2. Warranty as to non-existence of encumbrances. Goods shall be free from any charge or encumbrance in favor of any third party not declared or known to buyer before or at the time of contract. 3. Warranty as to quality or fitness by usage of trade. Implied warranty as to quality or fitness for a particular purpose may be annexed or attached by the usage of trade. The rule is, let the buyer beware. That is, the seller is under no duty to reveal unflattering truths about the goods sold, but this rule has certain exceptions. 4. Disclosure of dangerous nature of goods. Where the goods are dangerous in nature and the buyer is ignorant of the danger, the seller must warn the buyer of the probable danger. If not, seller may be liable in damages. Caveat emptor. Doctrine of caveat emptor means, let the buyer beware. The seller is in no way responsible for the bad selection of the buyer. The seller is not bound to disclose the defects in the goods which he is selling. It is the duty of the buyer to satisfy himself before buying. If the goods turn out to be defective or do not serve his purpose, or if he depends on his own skill or judgment, the buyer cannot hold the seller responsible. Exceptions. 1. Fitness as to quality or use. Where the buyer makes known to the seller the particular purpose for which the goods are required, and buyer should rely on the skill and judgment of the seller. The goods must be of a description dealt by the seller, whether he be a manufacturer or not. It is the duty of the seller to supply such goods as are reasonably fit for that purpose. 2. Goods purchased under patent or brand name. In case where the goods are purchased under its patent name or brand name, there is no implied condition that the goods shall be fit for any particular purpose. Here, the buyer is relying on the particular brand name. 3. Goods sold by description. Where the goods are sold by description, there is an implied condition that the goods shall correspond with the description. If not, then seller is responsible. 4. Goods of merchantable quality. Where goods are bought by description, there is an implied condition that the goods shall be of merchantable quality. There are 2 requirements for this condition to apply. 1. Goods should be bought by description. 2. The seller should be a dealer in goods of that description. But where the buyer has examined the goods, this rule shall apply if the defects were such which ought to have not been revealed by ordinary examination. 5. Sale by sample. If goods are bought by sample, this rule of caveat emptor does not apply if the bulk does not correspond with the sample. 6. Goods by sample as well as description. Where the goods are sold by sample as well as by description, there is an implied condition that the bulk shall correspond both with the sample and the description. In case the goods correspond with sample but do not tally with description or vice versa or both, the buyer can repudiate the contract. 7. Seller actively conceals a defect or is guilty of fraud. If seller sells by misrepresentation or fraud and buyer relies on it, or seller actively conceals some defect which couldn't be discovered by buyer on a reasonable examination, then the rule will not apply. Buyer has a right to avoid contract and claim damages.